All right. Hi, everyone. How's everyone doing? Good? Thank you. Someone has some beer. Well, welcome back, everyone. Hope everyone had a nice weekend. Anyone do anything fun? Anything interesting? Yeah? What'd you do? With what? Cool. Yeah, where'd you go? Very cool. And you did your reading, too? So you hung out and you did your readings? That's an impressive weekend. Hope everyone had fun and did the readings. Anyone else do only one of two? Hopefully the latter? Maybe. Okay. All right. So I'm passing around the signing sheet, but also the seating chart. Okay. So by now you should all know where you want to sit, and you hopefully found your friends and your enemies until you're sitting equally distant from each. Keep your friends close, your enemies, whatever. Make sure you write your name up so I can read it. Sometimes people write it upside down, and it becomes illegible, which makes it difficult for me. Let's see. Any questions on what we did last week? Anything about the whale case or the duck case or the any of the other hunting cases we did last week? The Indian case? Okay. So today is something of an orthodox class. I realized I gave you something that's not in the textbook. And usually when students see something that's not in the textbook, they say, oh, I don't have to read it. I hope you read this, because this will be very useful for you, not just in this class, but I promise you throughout all of law school and your entire legal career. And if I could take a step back for a moment, I'll say something that might surprise you. There's very little that I will teach that you will actually remember in 3 years. I promise you this, right? Most of the things I teach you, you will not remember. Yeah, you'll cram it in for the bar, but it'll fade out of your mind. This is a class that you actually will keep with you. Okay. Why is this a class you'll keep with you? Nothing to do with foxes or whatever they say, or hunting foxes. This is a class that teaches you how judges decide cases. Believe it or not, everything you do in 3 years of law school is more or less aimed at that question. Maybe instead of a judge, substitute a jury. It doesn't matter. How does a court, judge or jury, decide a case? Why is that the important question? Because every argument that you make, whether you're a transactional lawyer, whether you're a litigator, whether you're drafting contracts, is all with that goal in mind. How will a court handle this when it goes bad, right? If you're a criminal lawyer, how will a court handle my client's case when he breaks the law like this? Or if you're a contract lawyer, what happens when there's a breach? What's a court going to do with this contract? If you're a tort lawyer, a personal injury lawyer, right? What's my client's exposure? What's his liability if he does X, right? The actual black-letter law of torts and contracts and property is almost secondary in the long run, because I promise you won't remember this stuff. But what you'll remember are the different ways that judges can approach a question. And there's nothing new under the sun at all. The same way that judges decide questions today is how they decided cases at the time of Pierson v. Post, how they decide questions 100 years earlier in all these British cases I made you read from England, and even 3,000 years in the future, 2,000 years in the future, in Hogarth, right? This fictional Supreme Court. They decide cases the exact same way. Why? Because human nature has certain constants. The way people who have to decide cases in the time of Solomon and the time of Scalia have very similar approaches to judging. And that's what I want to convey to you today. So I try to juxtapose probably the most famous case from law school, which is Pierson v. Post. If you ask any of your friends or family members who are lawyers, they'll remember the Fox case. Just ask, yeah, the Fox case. They don't remember what it was about, but they remember the Fox case. So I take this case and I juxtapose it with a very famous article that was written, right? Called The Case of the Speluncean Explorers. By now you should realize this is a work of fiction, but it's meant to emulate or copy or mimic the way judges decide cases. And what I want to do this class is match them up. Try to compare the modes of reasoning used in the Fox case with the hiking case and with the Speluncean case. So as we're going through this class, try and keep in the back of your mind, how would the judges in the court of Hogarth resolve the Fox dispute, right? Who would give it to the hunter and who would give it to the jerk, and why? And I promise you by the end of this class, when we will get there, you will actually see the modes of reasoning are very similar. Okay? So why is this relevant? Well, when you're making arguments, legal arguments, this is what you do in legal writing in all classes, you need to appeal to the different modes of reasoning. You need to focus on things like text, focus on the purpose of a statute, If the statute's not very good for your client's case, how do you get around that statute, right? To what extent do judges consider popular opinion? To what extent should judges consider letting the other branches take care of an issue? These are the types of questions which will be in the back of your mind when you do anything. The actual black letter law you can plug in. That's easy. But the modes of reasoning is why you're in law school, right? If all you want to do is learn black letter law, I could give you a Barbary book that's this thick, give you 2 months, you could probably pass the bar. Probably half of you, if I gave you an entire summer without any laws, could probably pass the bar, right? Just by reading the books. That's not why you're here. That's not why you're being cultured into thinking and learning a certain way. And that's what I want to give to you at this early juncture of the semester before we've bogged you down with too much other law that you get bored. Okay? All right, any questions before we get started? Okay, I don't have the seating chart's making its way around. All right, so I'm going to have to ask for you to call out your names one last time, and then after that I can read your names off the chart. So I think I'm somewhere there-ish. Did I call on you last class? No, you. Yeah. Okay, what's your name, sir? Dylan. Dylan, okay, thanks. Someone's laughing, but it doesn't matter why. Okay. All right, so Dylan, let's talk a little about the Fox case, okay? At a high level, right? Describe the dispute in the Pierson v. Post case, just very high level. Don't go into the details too much.
Who gets the fox? The one that pursued or the one that killed him?
Okay, exactly right. Who gets the fox? And this might not seem very much different from the case about the whales or the case about the ducks or the other case we did last week, right? We have two parties, right? We have Pierson and we have Post. And Dylan, just so we don't get confused, who's who?
Pierson was the one that killed, Post was the one with the dogs.
Okay, good. So Post is a hunter, right? He's the guy with all the dogs and stuff, right? And then Pierson, I'm going to call him the jerk. Trust me, this will make it easier. The fact that they have both P names have tormented lawsuits for 200 years, right? So you can just call him the jerk. I'll know what you're talking about. I swear, last year in the exam, someone actually referred to the person as a jerk. I was like, all right, fine. I knew who they were referring to. Okay? So Post was the hunter. Okay? Post was the hunter. He had the dogs in the house. All right. So let's give a little bit of background first on the case before we get too far in. The case was decided in 1805. Okay? I'll go this way. Now what's your name?
Emily.
Emily. What do you think was interesting about the American legal system in the year 1805? And you don't need to know much history to guess at this.
There wasn't much of it.
Why not?
There weren't many laws.
Why not?
Because it was still all separate.
Why? What happened not too long ago from 1805?
Settled.
What?
We found America. Settled in America.
And what happened legally speaking in those interviews? Yes, okay. So we're talking an 1805 case, right? The American Revolution had been fought not many years ago. American independence was fairly new. And one of the first things the American lawyers did when they founded this new nation and liberty was we got rid of all the English law, right? We basically said, screw those Brits, we're going to find our own way. So all of the British statutes, all the British law books were basically tossed aside, okay? So we're in a weird state where even though there are lots of statutes that can be relied upon, they're no longer in effect. In fact, you may have noticed in the majority opinion, it said something to the effect of all these English statutes and positive law don't provide much help. Did everyone see that? The reason why is because we've just gotten rid of all their statutes. All these British cases were based on English statutes, which no longer bound the Americas. Okay? So if you think about it, this is an odd state. Even though there might very well be a law discussing who gets to keep the fox, those laws were thrown away. Okay? So we're back in our familiar territory. There's no positive law. This is like the case with the whales we did last week. There's no statutes governing it. So, Mel, what's your name?
Carrie.
Carrie. Carrie, what happens when a court's confronted with a case, property dispute over a fox, and there's no law on the books? What is a judge to do?
This court happens to look at a few different perspectives based on explorers and
Well,
old guys.
old guys, right? Okay.
So history.
History. Okay. So the court looks at some sort of historical customs, right? Practices. So look at these different philosophers. We'll come into detail with these guys, these old guys, right, in a few minutes. But in the absence of any positive law, in the absence of any, when I say positive law, I mean statutes, right, written down laws. They look to other sources. Okay? All right, so we know from the get-go, this is not going to be a regular case. This is not going to be where we cite New York Statutory Code 1524 governing animal hunting. That doesn't exist, okay? One other issue. So, ma'am, what's your name?
Amanda.
Amanda. So do you remember when we did the duck case, right? What was one of the ways that the duck case was different than the whale case?
The duck case was different from the whale case because the whale case talked about actually the mortal wound of harpooning, and then the duck case was more about the capture and I guess the chase.
That's right. But where were the hunts held in the whale case and the duck case?
Oh, obviously the whale case was out in the ocean, in the open, I guess public area, and the duck case took place on a man's property.
Good. Okay. I'm going to give you a phrase that any of you see this phrase or look it up? I might mention it class of time.
Yeah, it's like the land.
Yes. Okay. It literally means on your soil, right? Or property, basically, right? One of the things that distinguished ratione soli, pronounced, okay? One of the things that distinguished the whale case from the duck case was the whale case was on the open seas. Does anyone own the open seas?
No.
Of course not, okay? But the duck case, remember the guy built that entire convoluted duck trap with the nets and all the, yeah? That was on his private property. And we learned with that generally when a wild animal, this other term which I defined last time, feri naturae, which means wild animal, right? When a wild animal is on your property, it's presumptively yours, right? We did that with the duck case. When the ducks fly into your land, that duck presumptively belongs to the landowner. Okay? Everyone with me so far? Okay? So, ma'am, what's your name, by the way?
Shelly.
Shelly. Where was this hunt held?
I thought it was held on just empty public land.
Yes. It was basically what would be the modern-day Hamptons, only slightly exaggerating. It's the beaches of Long Island, where, if you can imagine at some point, unpopulated, unowned, public land. This is actually a map which won't mean much to you, but it was right by the water. Okay? So, what's your name? Samantha. So, when you're dealing on a piece of public unowned land that no one owns, and there's no statute governing the case, what the heck are the judges supposed to do there?
I think they should have looked to the customs, which is what they didn't do, but like they did in the well case. I think in there someone.
Well, let me stop for a second. Should the judges have looked at customs, or should the judges decide this case at all? Why were the judges in any business deciding a case where there was no law to apply? Think about it. What do you think? So what's your name?
Stephen.
Stephen, what do you think? Why are judges even deciding this case? Why don't they just dismiss saying, look, guys, we got no law. Take this to the sportsman dispute. Take it to your hunter's club. Figure it out yourselves.
We can establish a precedent.
Oh, what do you mean establish a precedent?
Well, most case law is basically based on precedent.
Stare decisis. You basically rule the same way that's always been ruled. So if there's no stare decisis, then you have to establish a new rule.
What's this? So you use this word stare decisis. What does stare decisis mean?
Basically, using the same rule.
Yeah, it literally means stand by the decision, literally. But it usually refers to precedent. Okay? Precedent. Okay. One of the interesting things, we alluded to this before, is this was a new country, right? They had just thrown away all these English laws. And the American judge said, all right, listen, guys, we got to start making our own precedents, right? This dispute on the beach, probably going to happen again. What's going to happen every time there's a hunting dispute and they come to court and we throw them out of court? Is that going to be a very effective court? No, not at all. So what the court said, and they usually did this language like, by our best lights, right? We got to do something. They come to us with a dispute. We need to provide some resolution. Something. We can't just say, I don't know, figure it out yourselves, because we're a court of law. We decide these kinds of disputes. So while a dissent, which we'll get to a lot more later, may have just been willing to say, this is stupid, let the hunters figure this out, majority opinion said, listen, we need to establish a precedent, right? We need to put something on the books so if this happens again, we can deal with it. Everyone get that? All right? So that's the frame in which this court decided. And if you want, you can draw a parallel to the Johnson case. That's the Indian case, right? Why the heck was the Supreme Court deciding this dispute among these Indian conflicts? Like, where did it get even the authority to do that? And basically, someone had to do it, right? Someone needs to decide these kinds of cases. And here, the court stepped in. Now, as it turns out, the judges in this case are actually quite noteworthy. They became later in life. The majority, Judge Tompkins, went on to serve as the governor of New York, and then actually served as vice president under James Monroe. He's a pretty distinguished guy. The dissent, which, as you might have noticed, was very sarcastic and very trying to be a smartass, right? This was actually Justice Livingston. And he would later serve in the U.S. Supreme Court. President Jefferson appointed him. So these were two very distinguished judges. And this case was re-argued several times. I mean, they wanted to get this case right for the exact reason he said. They wanted to set a valid binding precedent to deal with similar future cases. Okay? Everyone see that? All right. So now let's do the facts with a little bit more oomph, detail. Man, what's your name?
Jordan.
Jordan, give me the facts with a little bit more detail than we had before.
Basically, Post shot a fox.
Whoa, walk back. Walk me through the entire hunt.
Okay.
Yeah, I want details.
They were on a hunt, obviously.
Who's they?
Pierson and Post.
Was Pierson on a hunt?
No.
No, he wasn't. Who was on the hunt?
Post and some of his friends, I guess.
Maybe his dogs were friends. I don't know.
Yeah, I mean, dogs. He was just out on a hunt for a fox. And so he went out and he shot a fox and mortally wounded it.
No.
Did it?
No. Ma'am, what's your name?
Rachel.
Rachel, tell me what happened. Walk me through the fox.
Okay, so Post was hunting the fox with his dogs. He was pursuing it. There was nobody else around this desolate land. And so he was actively in pursuit. And then I guess Pierson comes along and just shoots him and takes him. So
right.
All the work Post did was no reward.
Okay, right. So here we have a situation, right? Post is the hunter. Okay? Post is the hunter. He has his dogs of imperial stature. You know, the big hunting dogs. If you want to see a picture of what this looks like, imagine this, right? You know, you have the huge dogs going after the foxes. Anyone ever do a fox hunt? Usually one. Usually from Louisiana. But anyway, so we have this imperial hunt with these dogs and everything else, right? And as I understand it, I've never gone hunting. Funny story though, but Justice Scalia has taken to Justice Kagan to go hunting. That's actually their new hobby, and they've done it several times, which is pretty funny because Kagan never actually touched a gun until she went hunting with Scalia. People learn, right? So apparently when you do fox hunting, it takes a lot of work to corner or to kind of trap the fox into some area. Okay? So Post comes with his huge dogs, and he corners the fox, right? And then at the last second, right, just as the hunter's about to take his kill, this jerk swoops in from nowhere, came out left field, right? And he killed the fox and took him. Okay? All right. So this might sound like the guy's just being a jerk, but they had a lot of beef, these guys, right? They had a lengthy history. And the actual value of the fox was worth much, much, much less than the value of this litigation, as you might imagine. I mean, this case got appealed all the way to the Supreme Court of New York, the highest court in New York. This went out for almost 2 years, okay? They hated each other. But even more than that they hated each other, these represented different views on culture, okay? So you might call Post a member of the aristocracy, right? Very wealthy guy, has enough free time to spend to go get the hounds and the dogs and, you know, spend all this time with this elaborate hunt. And the other guy, Pierson, was a farmer. He's like, screw this. These foxes eat my chickens all the time. I'm going to kill them so they stop eating my livestock, right? So you see there's like a different worldview between these two people. One is interested in this elaborate hunt, you know, with all the trappings and the horns. And if he spends an entire day where he's not working, you know, going after a single fox, that's the point of the game. And the other guy's like, screw this. These foxes are eating my chickens. I want to kill as many of them as I can, right? I don't really care about these elaborate hunts. He can go back to England, right? Oh, see, yeah, that was there too. There's a little bit of an anti-aristocratic sentiment in our new republic, which bans titles of nobility. All right, so that was the general fact pattern. Okay, so we have. Oh yes, ma'am.
Then why? I mean, if the judge just didn't care at all, he just didn't want these foxes, then why would he feel like he needed to do that?
He wanted to tell the people, stop hunting here. Stop wasting our time. They hated each other. There was a personal feud, and he was trying to screw him over. Is that a good answer?
Sure.
Yeah. I mean, there was a personal feud, but it also represented a bigger difference of worldviews of what you do with hunting and foxes, right? He didn't like the fact that he came here on his beach, you know, on the farm and all this stuff. He's like, we need to get rid of as many of these as possible. Okay? So what's your name?
Eric.
Eric. Eric, tell me. Okay, so the majority opinion. How does it go about deciding the case? We'll get to the specific old men in a minute, but generally speaking, sketch out, you know, how it resolves its decision. What's it looking to?
I'm trying to think of how to.
Talk it out. You don't have to get it all at once.
Yeah,
you got a lot of people ahead of you.
Because they got the very whole,
Mm-hmm.
they say that there is no right opposed. Yeah.
Louder, please.
I was saying, as a whole, if I'm correct, I believe they said that there is no right opposed.
Okay.
And I'm trying to think as in separation of individual opinions. I know they ask the question as far as property or right in the huntsman.
Well, I think you said something right. You said you're trying to reconcile the opinions, right? Are all the authorities they cite in agreement? Okay. There's a conflict, right? Okay. So the first thing we have to realize about this opinion is that there's a conflict. All these other authorities don't agree with each other. Okay? So Eric, what's a court supposed to do when there's some authorities going one way and there are other authorities going a different way? What does a court do there?
Either vote and majority wins, and then you got your dissenting opinions stated.
No. So you're writing the opinion for the majority, right? You have some precedents that go one way and other precedents that go the other way. What do you do as the judge? How do you decide which precedents to go on? You're the judge. Well, think of that. So what's your name?
Matthew.
Matthew. So you're a judge, right? You have some precedents that go one way and the other precedents that go the other way, right? You're not a lawyer, right? If you're a lawyer, you cite the precedents that help your case. You're a judge, right? How do you decide a case when the precedents cut both ways? You don't think about writing judicial opinions, but it's pretty damn important. What do you do?
The one you like.
What do you mean the one? Well. What do you mean the one you like? What does that mean, the one you like?
The one you agree with the most.
Why? What does that mean? You agree with it the most? Why do you agree with it more?
Because of your, political things sometimes.
Is this a political case? That the hunting of a fox is a Republican-Democrat issue?
Could be.
What do you think? If you're the judge, right? How do you decide? You know, you have two precedents. They're equally persuasive.
Be one that's going to be better for the public.
What do you mean better for the public? You're on the right track. What does that mean?
Like honestly, maybe.
What do you mean public policy? You're on the right track.
I don't know how to explain it.
Okay. Has anyone ever had an internship with a judge? Okay. I'd recommend if you ever have the opportunity to take an internship with a judge, do it. Because these are the questions you have to answer, right? It's a lot easier if you're a lawyer, right, to write a brief, because that means you cite all the precedents that help you, and you minimize the precedents that don't, right? But when you're a court, your obligation, is this done? Everyone sign this sheet? Anyone need to sign it? So I can actually use your names, right? Because when you're a court, you have an obligation to do something else. You're not trying to help one party win, right? So we have a couple answers which are on the right track. So that Matthew, right?
Yes.
So Matthew said whichever one you like better. Okay. And then is that Maria, right? Oh, you
It
Oh.
all messed up. They messed up. So we messed up.
This happens every. Oh my God. Okay. Okay. He's trying to trick me on day one. Okay, so that's Flora, right? Okay. See, I drew little arrows, right? Okay, so Flora said something about public policy, right? So one thing judges can consider is, what will the impact of my decision be on the people, right? So, okay, so now this is Maria, right? Maria, tell me, what are some of the impacts from public policy from this decision going one way or the other?
Like custom.
What do you mean?
Like what? Well, not custom, but I think it was like respectful, or that, you know, when a man was hunting, someone else shouldn't intercept. So I guess you have to look at that so that people won't get mad.
Okay, so one way of looking at it is, if we rule for the hunter, right, what will the impact of that be on the hunters?
Yeah, then hunters will, I guess it'll be like a rule from then on that once you see someone in pursuit of a hunt, that you can intercept it.
Uh-huh.
And then...
Okay, good. All right. So from public policy perspective, if you rule for the hunter, hunters will now know that they're free to go hunting and not have to worry about jerks. Right? Everyone see that? If I'm a hunter, I know that even if I corner a fox, I don't physically capture it, I'll still be okay. Now, is this Alex?
Yeah.
Okay, you also put your name in the wrong box. Okay, Alex. So you actually put in the right one, then you cross it out and put in the other one.
Well, you know, I did that because it's like on one side there's 4 seats, on the other side there's 4 seats, and this is the first one on this side of the...
You come up later, you can see it from my perspective.
Okay.
Yeah, that's what. Okay. So, Alex, what happens then for public policy if we rule in favor of the jerk? What does that do to public policy? Intercepted it.
Okay,
What lesson will society take away if we rule for the jerk?
That you can just come in and mess up somebody's...
Right, but what's the lesson that we learn from that, though? What's the result of giving it to the person who captures it? What does that do to hunters?
it makes them... Well, I mean, it's just saying you have to capture it. If you don't, then you don't have...
So how do you think a hunter would react to this ruling? Someone who has the hounds and all this other stuff.
Well, he's not going to like it.
Why not?
Because he uses all of his resources and time and day. And then if it's...
Do you think he'll be as willing to go on a hunt in New York anymore after this? No. Okay. So here we have these two different public policy decisions, right? On the one hand, if you rule for the hunters, you encourage this elaborate hunt. But if you rule for the jerk, the hunters will say, forget it. All right? So we have a couple of things. Which one do you like more? Public policy. Lynn, tell me, what's another thing that judges can consider when they're deciding cases? This one or any case? What's some other things they might want to keep in mind?
Oh, you mean Luke?
Looks like Lynn. Sorry, Luke.
Yeah, sorry. Other things besides public policy?
Yeah, she said public policy, things you like. What are some other things judges can consider when they're making these common law decisions?
And by public policy, I mean how it would affect.
Yes.
Then the whole precedent thing, it's like when you're using, back, I guess, I don't know if y'all covered it, I know you're trying to with precedent, like you can distinguish precedent, yeah, this actually doesn't apply to this case, so we're not going to use it, even though it would help.
I think you're on the right track, but what's the value of precedent? Let me ask you that question. Why is precedent important to society?
It allows people to kind of get a sense of how something's going to turn out.
Yes. What do we call that?
Prediction.
Close.
I think I know what you're getting at.
What?
The word's not coming.
Begins with a C.
Yeah.
Certainty.
Okay.
Consistency, certainty. Exactly. It promotes certainty. All right, you can fist pump. You can. It's okay. All right. What's your name now? Jonathan.
Sorry, you moved to me.
Yeah, that's cool. You fist pumping. That's fine. Jonathan, what? You got the right answer. What does certainty mean? What does that mean for a precedent to have certainty? Why is that important?
I mean, when future judges or court judges, like, they want to have a certainty of what the actual outcome, what outcome they get.
Not just for jurors. Who else is certainty important for? Who do lawyers work for? People. Yes, I know in this bill we call them clients, but they're actually called people, right? They're people who have problems and needs and desires, right? So if I am a hunter or if I'm a jerk, right, and I want to engage in some activity, I want to know in advance, what's going to happen, right? If I'm a hunter and I know, okay, there's this precedent, Pierson v. Post, right, that says that you have to physically capture the animal, right? If I know that precedent's in the book, I can adjust my conduct accordingly. Then maybe I won't go out with all the hounds. Maybe I'll just shoot the damn thing from far away, right? So I can actually kill it. Certainty is very, very significant, right? So that's another value that judges try to promote, certainty. Okay? All right, you got the right answer. I'll skip down to, is that Marcel?
Yeah.
Okay, Marcel, tell me. What's another thing that judges try to promote? And I'll phrase it a little bit differently.
Fair.
Ooh, you beat me to it. That was actually the second one I was going to do. I'll do fairness now. Yeah. What's fairness? Why is that something that judges can consider?
Why is it something?
Yeah.
People want fairness.
Oh, give me a little bit more. You're on the right track. Yeah.
I mean, in this case, he did all the work, so it's not fair to say that because he didn't kill it, he can't get it, I guess.
Mm-hmm.
I don't know. I don't know how to explain it. I just know.
Why do judges want to be? Well, let me ask you this. What does it mean for a judge to be fair? Oh, right. You say these words all the time. What does it mean for a judge to be fair?
I guess it depends on the case.
Well, someone mentioned Rawls. You're going to have to raise your hand, Elvis. Nick, tell me, what's fairness? What does it mean for a judge to be fair?
Maybe to choose a middle ground between both.
Why? Why are judges in the business of choosing these middle grounds? What's all this about?
I guess it could please both parties.
Or it's not so easy, is it? We also talk about, oh, that's not fair, or I'm telling, right, when you're a little kid. Is this Carson?
Yeah.
Carson, what does it mean for a judge to be fair?
In my opinion, I guess it'd be just following the letter of the law and not going outside.
So is that fairness?
It's fairness with respect to the law.
Okay. So let's look at this case, right, as a matter of pure fairness. You have the hunter and you have the jerk, and everyone admits this guy was a jerk, right? There's no question. Who do you give it to in this case?
I probably would have given it to the hunter, but when we're coming back to the fairness example, it's pretty unfair that someone just came in and stole the spot after he was hunting.
Right. Okay. So even assuming the majority opinion's right, and let's just pretend it's right for a second, the law says to give it to the jerk, I think we all have this sense of innate fairness inside of us. It says, you know what? This guy he got screwed. He got the short end of the stick. Let's go back up to, is that Mario?
Yeah.
Mario, tell me. What does it mean for a judge to be fair? Where do judges get this sense of fairness from?
I think reasonably applying the rule of law by maybe interpreting the rule of law.
What do you use this word rule of law? What does that mean? It's a great word. What does that mean?
As a president, he was saying, try to establish precedent, and then therefore lay out the legal law for others to go ahead and reasonably interpret that legal law and apply it in certain cases.
Okay. So there's this expression which many of you have seen. It comes up a lot. Rule of law. This is a phrase that's perhaps used a lot, but it generally means the opposite of what you said. But I'll explain why. Generally, the rule of law means a consistent application of law that's not swayed by passion or emotion or politics or partisanship. Justice Scalia had a great formulation that the rule of law is the law of rules, which you can accept or not, but I like it. It's great because it's simple, right? Or you might see it this way: the rule of law, not the rule of men. This was actually mentioned in the Speluncean case. Some of you might have seen this. The origin actually is John Adams. He actually wrote this in the Massachusetts Constitution of 1780, that we're a government of laws, not a government of men, which means that we're not governed by the whims and the whatever men want to do from here to there. There's a fixed, predictable, certain set of laws that are applied consistently, so people know what's expected of them. Right? This is a concept of the rule of law, which is a very important thing. Yeah, Scalia, his nickname is Nino, says it's true. It's very important. Okay, but a couple of you said something that fairness does play into it. So is that John?
Yes.
John, what role should fairness play in to any of these decisions?
I've been trying to think of what answer you're looking for. I'm not sure.
Oh, I'm not looking for something. I want to see, because listen, you're all human beings, right? Many of you are very smart people who'll be lawyers one day, right? You might be a judge one day, right? You're going to be sitting in judgment of your fellow peer, and you're going to have a statute in front of you, and the statute won't resolve the case 100%. You know, sometimes fairness is also called equity, right? Did you use that word in other classes, like equity, court of equity? Equity means fairness. To fast forward to the opinion in a few minutes, the Speluncean case, is it fair to execute these people who are forced to cannibalism because they're about to die? Probably not. They had no choice. Yet, of the 5 judges, fairness weighed on some of them, but not others. All right, we'll come back to this. But keep this in your mind. Whenever you tell a friend, oh man, that's not fair, or if you say a judge issued a ruling, say, oh man, that ruling was so not fair to the plaintiff. Try and see what are the guidelines that come in, and someone cited Rawls, among others. We have human morality, right? When we come to law school as lawyers, when we come to the bench as judges, we come with us certain values that we bring, and these are the values we see through the law. And one thing I want to dissuade you of, and someone mentioned this, is it's not all about politics, right? This is a Fox case. It's absolutely nothing to do with Republicans or Democrats. But there are certain values which we all have that kind of guide how we view the law. And there's nothing inherently wrong with that. We don't want robots coming to the bench. We want people with experiences and values, right? These are positive human developments that we have. We might not always agree with it, but there's nothing wrong with this inherently. All right? Questions? I'll move on. Okay, one other value which judges, no, I'll give it to you. You might not get it, is efficiency. So that's Tamara? What's efficiency? What does that mean? In the context of the Fox case, right? What would it mean? Which ruling is more efficient? Why is it more efficient to rule for the juror? Yeah. Why not? Okay. Okay, very good. So one of the things that common law decisions want to do is promote efficiency, right? They want to stimulate certain behavior. and this is similar to public policy, it probably blends together a little bit, right? If the court wants to promote hunting, right? So that's Harrison. So if the court wants to promote hunting, right? Which was the more efficient ruling? Okay, you rule for post, right? And now what if the court wants to promote killing of vermin? Right? Vermin, right? Vermin. Right, that.
It's VARMIN.
Okay, whatever. Vermin. Okay. Say, thank you. Say the different goal is, instead of promoting hunting, is you want to kill these annoying foxes that prey on chickens, right? Right. You're trying to get rid of as many of them as you can. So, oh, I know your name, Jesse. Jesse, what's the ruling if you want to promote killing the vermin? Who do you give the judgment to in this case? Which is an easier way to catch foxes? To go with the hounds and the dogs, or to shoot them dead? So who do you rule for? No, I'm asking you for efficiency. You're trying to kill as many foxes as possible. Who do you rule for?
I rule for the jury.
Why do you rule for the jury?
Because whatever promotes having the animal yield more eradication.
Yes, you rule for the jerk because the jerk will kill more animals, right? If I'm a farmer and I want to save my chickens, I'm going to shoot every damn fox I see as quickly as I can. I'm not going to wait for the hounds to come. I'm not going to blow the horns. I'm not going to wear the outfits, all the other stuff, right? Okay. So is that Aaron? Okay. So you're a judge, right? How do you decide which goal you want to achieve? Promote hunting or promote killing the vermin? How do you decide which goal you want to achieve? If you're a judge sitting in New York in 1805.
In 1805, I guess it would be different.
Yeah.
To think about the country or society altogether.
Mm-hmm.
What's more important, the hunter or killing the vermin, or
what
this comment says, what's more important to just have it deal out?
How are you, Aaron, Judge Aaron, sitting as a judge in 1805, supposed to make that call?
You have to think about the future.
Future? What do you mean the future?
You have to think about, I guess, what's going to be the best way to handle the situation in the future, as far as what's going to come on later on. How's it going to be easier to decide based on what you choose now?
Okay, that's good. Alex, what do you think? How do you decide if you're a judge between these two competing goals? You have to pick one. You can't pick both.
I mean, I think it comes really down to efficiency of the court. The decision to make needs to be not waste the court's time.
Well, let's see. Is that Amanda?
Yes.
Amanda, tell me. The majority opinion, right? Which goal does the majority opinion think more important?
Well, it seems that they're going for a more efficient approach. Because if you rule for the hunter, then what's the limit? Where's the timeline? I mean, the hunter could easily say, well, I was...
No, you're right, but I want you to answer this question. Which goal of these two, one or two, did the majority opinion side with? Of the vermin, right? Why?
Because I think that's more efficient.
Well, they're both equally efficient for different goals. Everyone see, right? If you want efficiency for killing vermin, you rule for the jerk. If you want efficiency for promoting hunting, you rule for the hunter. Everyone see that? Okay. Chad? Why did the majority decide to pick the second goal, killing the vermin? What motivated the majority there? Explain more.
It was easy to show who has it, right? Versus who, we talk about who's been hunting it versus who has it in hand.
Okay. There's something very specific I'm looking for, and someone actually wrote it here. This tempora mutanter. Who knows what that means? Anyone look it up? Yeah.
Time changes things, or things are changed by time.
Okay, good. Okay. It basically means time change, and so should the law. But was this the majority of the dissent? This was in the dissent, okay? So let me walk you through this. All of the old men, right, these old men, all of the old men that were cited did not exist in the time of the hunt. They wrote in the time of farmers saving their chickens. Okay? Justinian, for example, his main concern was protecting chickens. So all these old Roman and British scholars, they were concerned with killing the vermin. Right? Certainly, we as a society can recognize that circumstances have changed. That we're now not so much concerned in protecting vermin. We want to promote this elaborate hunt. So actually what happened was interesting was the majority opinion felt compelled to stick with all these old precedents, these old men, where they were worried about hunting and killing chickens by the foxes. Whereas the dissent said, listen, times change. Tempora mutator, right? Hakuna matata, right? Times change. No worries. Let's evolve our precedents to pick this first goal. Let's try to promote hunting. Let's not so much worry about the foxes killing the chickens. Everyone see that? Everyone get that? Okay? So this is a nice segue then to getting into all these old men, as one of you aptly called them, right? All these scholars, right? All these writers who develop these different theories. And I'll give you a couple names who are mentioned, right? So there's Pufendorf, there's Grotius, oops, I can't spell his name, sorry. There's Pufendorf, there's Grotius, there's a guy named Barbarac, and there's also someone named Locke, who's not actually mentioned, oddly enough. Okay. Justinian too, he was a Roman emperor, which I'm not so concerned about right now. But I want to focus more on these natural law guys, right? These men, okay, they were known as writers on the natural law, okay? Okay. What is this natural law? I think I mentioned this when we did the Indian case, among others. Is that Judson? Sir. Justin, you remember what this natural law is, what these writers were trying to write about?
I'm not sure that could apply to this case, but with the Indian, talking about the Indian case, was the precedent was said that the Indians have possession of the land, so it's there, so long as they maintain possession of the land.
Well, okay, well, that's good, but where did John Marshall get that rule from? Okay, right, okay, so now where did all these old guys get it from?
That was just the history. That's just the way it was done.
Okay. All right, so the word natural has a lot of meanings. You may have seen if you studied theology or any kind of religious studies. Okay? But for our purposes, natural law was a way to explain property rights. What do I mean by that? Why is it in the Indian case that the nation who got there first and conquered it got to keep it, right? Well, they effectively said that these Indians were savages and they were not able to obtain property rights. Okay? So what happened? The act of conquest, right? The act of conquering the people of those countries, that was enough to give a property right. Okay? So that explains perhaps property in the Americas where it's all brand new. But how do we explain property back in Europe, where the people have been there for lots and lots of years, with many civilizations? Okay? Ravi, tell me why in Europe, right, where you have many different warring people, in the first place, how did the societies decide who gets what?
Well, originally I would say
natural law and the state of nature.
Ooh, good. Tell me, what's the state of nature?
The state of nature basically said that everybody, originally everybody roamed around just, killing and taking what they want, and then societies were built, and after that, people bonded together to protect what they had.
And what was that agreement called? I heard someone say it. Social compact. Okay. All right. So Robin, that's right. Let me walk you through this. Okay. So a lot of these natural law theorists try to explain how is it that we have property rights? Like why do we have property rights? So they imagine in their heads this origin. Maybe it happened, maybe it didn't. It doesn't even matter, right? What they call the state of nature. I'm not talking about the Garden of Eden or anything like that, right? I'm talking about some early state for man, where people basically, like Robbie said, ran around and killed each other, right? If I got a buffalo that I hunted, someone wants it from me, they'll just kill me for it. And then we discussed in this discussion last week, right? When you have two different tribes that are both hunting buffalo, they can reach an agreement, say, okay, I'll take these, you take those, and we won't kill each other, right? That agreement or compact, if you think about it, was a way to divvy up property rights. You get those buffaloes, I get these buffaloes. So what these natural law theorists basically said was, okay, we have all this violence and chaos, people acting irrationally. Let's come together, make this social compact or social agreement, and we'll create property rights. What they thought was the purpose of government, the very essence of why we have society, is to protect property rights. So the class is important, more important than you thought, right? The reason why we have government is to make sure people don't kill each other for buffaloes, is to have some sort of neutral agreement, some sort of neutral understanding of how property rights are divided. Okay? So all of these guys, Pufendorf, Grotius, Barbarack, Locke, they all said we start in this state of nature, right? We start in the state of nature, and then we can acquire property rights, which then others are required to respect. Everyone get me so far? Questions? Okay. So this raises the key question. So Gary, the key question is, all right, if you acquire property, you get to keep it. But how do you acquire property, Gary? How do you acquire property? And from the state of nature, how do you acquire a piece of property? Okay, good. And what's the significance of conquest? What does conquering people do? What does it show to the world? Yes. Yes. When you conquer someone, you are displaying to the world that you have now taken them. I mean, you physically, literally have to capture them. Okay? So let's turn from conquering a people, which is a lot more complicated. Is that Summer? Let's talk, instead of conquering people, let's talking about capturing animals, right? How do you obtain a property right in an animal?
Either by the pursuit of the animal or are you talking about in respect to?
I'm asking you.
I was deciding it would be the
Okay, so there's two ways I think which you're alluding to. The first one is chasing an animal, right? Pursuing it. What's the other way? Touching? Touching it? Right. But making physical contact, right? Okay. So if you're deciding, right, how do you capture an animal? I think Summer hit on the two, rough ways of doing it. One, you can say, well, if you're chasing an animal, pursuing it, that's your animal. The other way is you have to either kill it or perhaps mortally wound it. Okay? So, man, what's your name? Oh, no, I have your name. Sorry, it's force of habit. Rhiannon. Rhiannon. The majority of these natural law writers, right, what did they think of as a way to obtain a property right to an animal? Yes. Okay. So Pufendorf and Grotius, right? Oops, that's for a comma. Pufendorf and Grotius said you have to physically kill it, right? Okay? This is called the rule of capture. Remember this, we'll come back to this a couple times. The rule of capture. Okay? Ashley, what is this rule of capture? What does that mean? Or yourself, either way. They should be the same. What does this mean, rule of capture? Ooh, what does that mean? Okay. All right. The rule of capture generally means you have to make some physical contact. Some physical contact. And it varies, right? I think Ashley's answer references that. Varying degrees of physical contact, right? For some of these guys, Pufendorf and Grotius, said you have to actually kill it. Some of them said you can catch it with a net or a trap. Some of them said you can, there are no guns, right? You can throw a rock at it, right? And if that rock kills it, it's yours. This is similar to what we did with the whales, right? It's impossible to actually physically take the whale. The way they got around it is they would take the harpoon with their symbol on it, remember? And they threw the harpoon to the whale. So the rule of capture has different elements. You can kill it, you can trap it, you can wound it. And these are all different. This is why when she said, according to Grotius, I wasn't so concerned, right? These are all different ranges, right? So you can kill it, grill it. No, that's Nugent. You can kill it, right? Trap it, wound it, right? There are different ways of getting the animal, acquiring it, capturing it, if you will. Everyone see that? Everyone with me so far? Okay. Now, Summer mentioned the other one. Is that Troy? Troy, what's the other approach? Not the rule of capture. Good. Okay. Okay. What do you mean by pursuit? Good. Use the word effort. What's a good synonym for effort that we mentioned before? Labor. Okay. So you have what's called the rule of capture. We'll call that number 1, right? And then number 2, you have what we might call labor theory. Labor theory, okay? Labor theory, as Troy said, is based on pursuit, chasing an animal, right? Meredith, right? Tell me, what does that mean to pursue? What does that signify?
It signifies work, labor.
Well, let's try and define it without using the word. What's the importance? Why would the courts reward someone who pursues the fox?
Because it promotes society.
You're on the right track.
It would promote people to work, not to just get out there and
be a jerk, right?
Yeah, be a jerk.
Yeah. Okay, that's good. Adriana, what do you think? Why would a court want to adopt labor theory versus rule of capture? What's the advantage there to labor theory?
Just give it to somebody, then people aren't going to want to put in the effort to actually hunt the animal.
Okay.
They're saying, like, why am I going to go out there and hunt and somebody else is just going to come and shoot it? I don't have to do the work somebody else is doing.
Very good. Is that a question? Okay. That's right. The advantage of labor theory, right? The advantage of labor theory is that it encourages, it creates incentives, if you will, for people to go out and hunt. Okay? So the labor theory is most closely identified with John Locke, who you probably have heard of, and a guy named John Barbarac you've probably never heard of. Everyone knows Locke, no one knows about Barbarac. Barbarac came later. It's kind of like a disciple of Locke. Okay? And they basically said, listen, if you see a rabbit and you start chasing it, after a while, that rabbit becomes yours. Okay? But there are two competing, right, difficulties with these two theories. Certainty and fairness, right? We mentioned these elements before. Right? So, that's Samantha? Samantha, which one's more fair? Which one's more fair? The labor theory or the capture theory? Why is labor more fair? See, we asked you the same question I asked the guy over there. What does it mean it's not fair? Ah, it's hard, isn't it? It's not easy to define fairness. Rafi.
Can't you argue it the other way? Because certainty says that it's certain that this person owns the animal, whereas if you're just chasing it, there's no certainty that you're going to actually capture the animal.
Okay, that's my next question, right? So Ravi, which one's more certain?
It's certain that the person who shot the animal and has the animal.
Which rule is more certain? One or two?
The rule is more certain. One to capture it.
Okay, that's my next question, right? Capture, right? Capture is more certain. You see more said it. Cassandra, why is a capture rule more certain? Yeah. Right. When do you actually get, right? When do you actually get the property right? Right? At what point of chasing? Cassandra said, this guy could have been chasing all day. Maybe the hunter was an idiot, right? Maybe he was hunting in all the wrong directions. He was running around like a fool. And this other guy's a pretty good shot him from across the field. Right? How do you measure effort? We did this with the whale case, right? When you have two different whaling boats going after the same ship, someone said, oh, what happens if one whaling boat set out sooner? Well, maybe one whaling boat set out sooner, the other was a much smarter whaler. Right? The measure, right? The measure of labor theory is very difficult. So the dissent said, actually, this is the dissent. Did anyone get the test from the dissent? This wasn't totally obvious. Does anyone have it? What was the dissent's test? Yeah.
Just if it's pursued by hounds and big dogs, then it's whoever's hunting.
Okay.
And then if it's pursued
you're not wrong. So the problem is the dissent was being a real big jerk, right? Even the dissenting judge, he was being facetious about the hounds and the dogs, right?
Okay, good. Because that seemed a little arbitrary to me.
He was being a smartass, right? There's no other way around it. He was being a wise guy. Did anyone see it? It had to do with reasonable prospects. Anyone see that? Okay. So what the dissent said was, how much labor is enough to actually acquire a property right? You have to within reach, right? And have a reasonable prospect of taking the fox. A reasonable prospect of taking the fox. Doesn't sound like a test you have read like in contracts or torts or something, right? Reasonable, right? What's reasonable? Well, that was a rule the dissent would have had. Was there a reasonable shot of getting the animal? Right? So, I mean, in this case, in my experience, resolved the issue. If, say, the hunter was, say 50 feet away and he was charging at the fox, it was a pretty good shot. He was going to get it. But then the jerk swooped in. Okay, but let's think of another case where the guy was, say, a mile away from the fox and he'd been hunting for 5 minutes. Was there a reasonable prospect of taking it? Probably not. But you see the difficulty, right? Once you start applying labor theory, you actually start measuring how much labor. The capture rule is certain, right? Why is it certain? Because he got the damn fox. It's in his hand. He has it. There's no question. Someone said evidence there. The evidence is clear. You go to a court and say, Your Honor, got him. Right here. Got the body. It's like, all right, judgment for you. That's easy. Common law judges like certainty because it's easy. The dissent, this labor theory, that's hard because you can't quite measure it. Okay? All right. So everyone get the gist, right? We have these natural law theorists. We have, Pufendorf and Grotius, who had this rule of capture. that said you have to either physically kill it or trap it or wound it. And they had this competing theory, which was the labor theory, which says if you pursue it enough and there's a reasonable prospect, right? Reasonable prospect of capture, then that's enough. And that's a Barbarack and Locke. Now, the majority, the rule of capture, I don't know why. And then the dissent took the labor theory. Which theory do you think is more popular in American law? Jacqueline? Which theory do you think caught on with American judges? I wish. No, the other one. Yeah. This is the majority opinion and the majority rule, right? To the extent that there is a majority rule in this question in American courts, it's the rule of capture. Now, Jacqueline, why do you think this rule caught on, the rule of capture?
I mean, I guess the courts are trying to reward the person who actually obtained the object and take claim possession of it. I guess for efficiency.
Good. Okay. So it's efficiency. What's the main value, Ashley, that the capture theory promotes? I said it down here.
Certainty.
Certainty. Okay. If I had to guess, and I don't know, in the minds of American judges, the certainty of the capture theory makes the better rule. This way, judges don't have to get into these messy evidentiary issues like how long were you hunting? How many dogs did you have? How big were the dogs, right? Were they hounds or were they beagles, right? These stupid questions, right? You say, do you have the fox? Judgment. Piece of cake. And by setting this precedent in 1805 and by taking a lot of time, they've now made it very easy for other judges to resolve these issues, right? So even though they were on a blank slate, there was no law to begin with, now they have this precedent, and if there's a dispute in the future, give it to the jerk. Piece of cake. All right, I love this case. Spending almost an hour on it. Any questions on the case on Pierson v. Post? The capture and the labor theory are important, but all the other issues are so much more important. That's what you'll remember. Yes, ma'am.
You were talking about efficiency for efficiency for the hunter, efficiency for the jerk.
Yeah.
But I think that at the end it really came down to efficiency for the court.
Ah, what do you mean efficiency for the court?
Like for them to do the
people are lazy, right?
Yeah, because that's what I was wondering. We didn't talk about efficiency for the court. That's really what it came down to.
Well, I think that's an issue. Someone said evidence, right? Which ruling is more certain for the court? But also think about it this way. Assume that most disputes never go to court, right? You have two people, and this happens to them. They don't hire lawyers. And they go, hey, what's the law? It's like, oh, yeah, you know what? The law says if you catch it, it's yours. And like, oh, man, okay, you win, right? So it's not just for the court. This is why I want you to think. Law isn't just about court. It's not just about clients. They're called people, right? People act on a day-to-day basis in accordance with the law. And if you're a hunter and you have this one in the back of your head and then some jerk takes your fox, say, you know what, you're a jerk, but I know you win, so screw it, right? So you're right. It's certainty for the court, but it's more important certainty for society as a whole, that society knows what's up and what the rule is. Any questions? It's a good case. So a funny afternote, right? The actual cost of the fox was 75 cents. I mean, this was like in $1805, right? He claimed $25 in damages, the hunter did. So basically, the value of the damage was like 30 times the amount the fox is worth. And after all the appeals were done and lawyers' costs, the total judgment was $121. So basically, the original fox was 75 cents in judgment, and after everything, it was over $100 in fees. So there was a lengthy feud between these two guys. So it was about much more than this case. Yes, ma'am. Oh, that's okay. Okay. Yeah. So. All right. Any other questions? Move on to the Speluncean case. Okay. So let's move on to the Speluncean case. So this is probably something which I hope that every law student at some point in their career reads. You're not required to take any kind of jurisprudence class, but I wish you would. So this is your own little insight into how is it that judges decide cases? So a little bit of the background. This is a story that was written by a law professor at Harvard. It was written in the 1950s. And it's so good that it's still taught every year in law schools across the country. And so many people have tried to make, sequels to it and prequels to it and like alternate opinions. They all suck. They're all bad. The original one was the best one, which is why I have you read it. So the setup and then the facts I'll run you through fairly quickly involves a bunch of cave hikers, right? These guys who hike through caves. Anyone ever do spelunking or hiking through caves? Do you ever worry about getting caught and getting stuck?
Yeah.
What kind of provisions do you usually bring when you go through these caves to make sure you don't get stuck? Yeah. You bring a lot of food and water? Not really. Okay. So these guys, yeah, right? Bring a knife. So these guys, these were hikers, and they went hiking through some cave system, and a huge boulder fell in and blocked their exit. Okay. By the way, this is happening in the year 4,299. So it's some fictional point, 2 millennia into the future. Okay. So yeah, they get blocked in, and wisely they told their friends they were going to be hiking. So they find where they are, but they can't get to them. They can't get to them at all. So on the outside, they have all these repairers and excavation equipment trying to get to these hikers. And in the process, 10 people die trying to rescue them. Do you ever notice whenever their hiker goes missing in the mountains where he's like hiking in the middle of the blizzard, people usually die trying to find him? Think about those people, right? It's somewhat... I'm anomalous where I would not even... If you go hiking in one of those blizzards, I'd be like, okay. Good luck. But it's a good thing I'm not in charge. It's a very good thing I'm not in charge. I'm only in charge of you, which I guess is much worse. Okay, so there were 10 men killed. But basically, the rescuers decide it's going to take, 30 days to rescue them. Okay? They won't get to them for 30 days. It's a drill. There's a radio inside this cave, which is turned on, and they start communicating. And they find that they didn't bring much food. They didn't bring much water. And on the 20th day, they say, listen, we're not feeling good, right? Here's our mental conditions. Here's our physical conditions. Here's how much rations we have left. Let me talk to a doctor. Okay, so they put a doctor on their phone. Doctor says, you guys are not going to make it 10 more days. You're not going to make it 10 more days. Okay? They say, okay, is there any chance you can rescue us within 10 days? And they say, not a chance. Okay, so then the radio goes silent for about 8 hours. Okay, radio turns back on. Okay. And then so one of the guys, Wetmore, says, can we survive if we consume the flesh of one of us? Right. Can they survive if they eat the flesh of one? They're trapped. They're going to die if they don't. And the doctor says, yeah, you will all survive. Okay. So then they say, it goes silent. Then they come back on and says, well, what happens if we cast lots? Throw a dice. Whoever gets the highest or lowest number will be eaten. And the doc is like, dude, you're on your own. I'm not giving you advice. They ask, is there any lawyer or a judge or a government official? And it's like we're not helping you, right? And then they say, is there like a priest or something? It's like, that's all on you. Okay? So then the radio goes silent. And on the outside, they assume that their batteries died. But that's not what happened. What happened on the inside was that 3 days later, after this phone conversation, they all cast lots. They threw a dice. And immediately before throwing the dice, Wetmore, right, the guy on the phone says, wait a minute, I got second thoughts. I want to back out of this contract, right? And they're like, nah, this was your idea, buddy, right? Okay. And so, they take the dice. Everyone agrees it's a fair dice. It's a fair dice. Throw the dice. Wetmore had the lowest number. They said, you have an objection to the throw? It was a fair throw. Okay, so then they kill him, and they eat him. And with that nourishment, they were able to survive the 32nd day. So actually, the rescue took even longer than they anticipated. But they had enough nourishment to eat it. All right. Now, did you study in criminal law case of Regina versus Dudley and Stevens? Where, okay, so this is loosely based on, this is the case you might recall where the men were shipwrecked at sea, right? And basically they have to turn to cannibalism, okay? So the men are arrested on the 32nd day. They're brought to the hospital. They recuperate, and then they're indicted for murder. Okay. Now there was a choice, right? Did the prosecutor have to bring a murder indictment against them? He didn't. He did not. He could have brought a charge for, as one of the judges, consuming human flesh, perhaps, right? Or some lesser charge. What was that?
Corpse desecration.
Yeah, desecration, necrophilia of some sort, right? So there was an option, okay. But they bring an indictment, they bring a charges for murder, right? So the foreman of the jury, who's a lawyer, says, Judge, we're not comfortable making this decision. Let's do a special verdict, right? Where we're going to find the facts, and then you, judge, can decide guilt or innocence. And the judge is like, all right, fine, I'll do this. So based on the facts, the judge says you are guilty of murder. You willfully took the life of another, right? That's the standard definition of murder you study in every one of your classes. Okay? And there's no discretion in the sentencing. The only sentence is death, hanging. There's no leeway. There's no life in prison. Okay? So they appeal this to the Supreme Court, right, of this fictional town. And I want to walk through the different opinions, if I may, to someone saying I've not read it before. So right. So there are the 5 decisions, right? The first one is by Chief Justice Truepenny. Okay. Okay, so the Chief Justice basically says, listen, you follow the statute. Statute is clear. Statute says if you willfully, take the life of another, that's murder. Right? But the Chief Justice says, I ask the executive, who I guess is like the president, for clemency, which is, a pardon. The Chief Justice is saying, listen, let's follow the law, right? Let's do our jobs as judges. But this isn't fair. Right? This is not fair to execute these people. They went through a terrible ordeal. So instead of me reading the statute in perhaps a weird way to let them go, I'm going to officially ask the president to let these guys go. All right? So there's a fairness issue here, right? We talked before about the rule of law. Should judges be in the business of asking the executive to pardon people? Should judges be in the business of crossing the separation of powers and making demands on the executive? So I want to do this for each judge. But who here thinks they would agree with this opinion? Hands up if you agree with it. All right, why?
Sort of like a melding between the guy who accused himself and the other one strict statute. Sort of like melding a dispute is the guy who accused himself said nobody would commit suicide. We're in a crazy situation, and they did what they had to do. So I agreed with that. I also agreed with strict statutes. So this particular person melded those two, so I thought.
Okay. All right. Anyone else on this one? Yeah.
I agree with him, like what she just said, but I don't think that I don't think the judge should ask the executive for
Okay.
pardon. I think the executive has that.
Do your job and let him figure it out.
I mean, yeah, let him figure
Same?
it out.
Most.
Yeah, and I agree. He actually voted guilty.
He did.
And that part I agree with. Just the clemency part is not his business.
Okay. All right, let's move on to the second one, okay? The second one I'm going to call 2A and 2B. Because Judge Foster had effectively two different opinions. I guess he was of two different minds, right? Right? So I'll call this, Foster A, right? Foster A bases his theory on what we just studied 5 minutes ago, natural law and the social compact. What he argued was basically, even though we have a murder statute on our books, these guys were effectively in a state of nature. These were like the whalers at sea, or hunting foxes on the beach, or conquering the Indians of the New World, maybe. Even though our laws are on the books, right? Why were they in a state of nature? Because our society couldn't reach them. Even though they were a few feet away from us, that boulder may as well stop civil society. It blocked them. Our courts couldn't reach them. Our police couldn't reach them. Our rescuers couldn't reach them. They were on their own. They were on their own. What? Yes. Yes. They were on their own. And because they're on their own in their own state of nature, and make their own social compact, right? Okay. And what was their social compact? It wasn't a murder statute. It's whoever threw the lowest number died. That was their agreement. That was literally their social contract. And Foster A, the first one, says, we should respect their social compact. The same way that the whalers had their custom of hunting the animals, and the ducks had this custom, and the hunters had this custom, we should respect their agreement. Everyone see that? It's as if this happened in a different jurisdiction, in a different country. Our laws have no applicability inside this cave. Who here agreed with this one? Someone. Yes, sir. That's Eddie. Go ahead. Explain why you agree with this one. Yeah. What do you mean takes into context? I think it's the right rim. What does it mean take into context?
The normal laws, the rules of normal existence, aren't applicable. There's just a totally different scenario.
Okay.
Desperation-wise and survival-wise.
I saw a hand there somewhere?
Yeah.
Amanda, let me ask you this question that Elvis posed, right? At what point do you get to the state of nature? Like, what exit is on the the beltway? Right? When do you get to the state of nature where our laws no longer kick in?
Well, in this case, they were separated from society for a period of time where they were unable to survive without like additional nutrients and so on. So I think once you get to the point where you have to figure out how to sustain yourself because there's no outside help and you physically could not go on, that might be a line.
Okay. Okay, Judson, let me ask you this question. Where does Judge Foster get the authority to impose the rule of nature on these people? He's a judge sitting in the Supreme Court of this jurisdiction. He has a statute book. What gives him the authority to disregard the statute? Okay, so she can't. Go ahead.
Say again.
Go ahead, please.
Well, I was going to say that I don't think you can draw a line. I think that it's a case-by-case basis.
Okay.
Because you can't sit here in society and draw a line because you're not in a situation.
Yeah, but the judge isn't here in society. What authority does the judge have to adopt this rule? What authority does the judge have to say, you know, these guys ripped their own social compact, right? Imagine if two of you go back into the bathroom and you start having a fight. Say, oh no, Dean, we made our own social compact. We agreed to fighting here. We're on our own here. Why does a judge have the authority to make their own or to adopt his own law? Anyone? Yes, ma'am. That's Elise? Says who? So this is the difficulty, right? Judges start looking outside statutes. you have to ask yourself the question of where do they get the authority to do this, right? So let's go to Foster B, I'll call it. And this is what we might call a statute's purpose. I'll answer that question. Someone asked, why couldn't they just cut a piece off instead? Okay, because you bleed out and die, and you can't eat dead meat, right? If you're a hunter, you can't eat a dead animal. You can only eat the animal shortly after it's alive because it gets, ill. So cutting off his limb, he'd bleed out and die, and then you couldn't eat the rest of him. No more questions on this. No more questions on this. Right. That's all you get. All right. So the purpose is this. Like, listen. Okay. So sure, right? We have this murder statute, right? But what's the purpose of this law, right? The purpose of this law, the Judge Foster says, is to deter murder, right? Because, if I kill someone, then they'll execute me. Does this concern apply when you're inside of a cave and you're about to die? No. If you're in a cave and you're about to die, you're going to take your chances with a jury, right? Because if you don't, you're going to die. So you read into this law an exception based on purpose. The problem with this, though, is that there's several purposes for a murder statute. There's not just one, right? It's not just one statute. You want to punish the crime. You want to deter. You perhaps want to rehabilitate. Remember you studied in criminal law all the different justifications for crimes? Right? There are different ways of doing this. But the judge identified one purpose, what might be called his value or his opinion, and that's what he used to make his decision. So we're running a little bit short on time. How many people agree with this one? No. Okay, good. So let's go to the third judge, right? The third judge is the interesting one. This is Tating, right? Tating withdraws. He can't decide the case. So with a couple of you, I asked you about fairness, right? And you had a really tough time answering my question. This guy really had a tough time. He's saying, I see both sides. I think they both have good arguments. The statute says one thing, but fair says another. I throw my hands up. I don't know. I don't know. Right? Do we want judges to throw their hands up? It's a tricky situation. But what's the effect of him throwing his hands up? Guilty. Because when it's a tie vote in a court of appeals, 2 votes to affirm, 2 votes to reverse, you affirm the conviction. You affirm the conviction. You affirm the lower court. Okay? The fourth judge is also kind of interesting, right? So this is Keene, right? And Keene says, follow the statute, be damned. Follow the statute, be damned. The statute says willful murder. He did it willfully. That's it. We don't care. Right? I'm going to put this on one page. We don't care about purpose, right? We don't care about the state of nature. All we care about is what the statute says. I'm a judge. I was appointed here. And he references this funny history, this time of this great spiral, where there was a time where there was a chief justice of the court who clashed with the executive, and there was a civil war. Think about that for a second. There's no obligation for courts to be listened to. They have no power. Courts only exist as long as they're legitimate. People respect that. When courts start clashing too much with the other branches, you can have a serious crisis. And this case was actually a civil war. Okay, I have 1 minute left. The fifth judge was Judge Handy. And he said, oh, this is easy, right? This is easy. Public opinion. Look at the polls. 90% of the people want to let these guys go. Okay? What's the problem with public opinion? The judge isn't deciding for himself. He's looking to the will of the people, not what the law says. Yet, what's public policy? Right? A lot of you said public policy. The same decisions of public policy are what the public thinks. So let's try and think about this way, right? Now I'll wrap up with this, right? Who are the Chief Justice that voted for, right? The Chief Justice said, you know, follow the law but don't like it. He probably would have given the fox to the jerk, but said, I hope he gives it to the other guy, right? Okay. What about Justice Keene, the guy who said follow the statute? He would have said, you know what? The jerk gets it. Too bad. What about Foster, right? He would have said, well, what's the natural law say? What are the agreements of the people? What are the customs of these people, right? And what about Judge Handy with public opinion? He said, you know what? What do the sportsmen want to do? Just ask them what to do. Go take a poll of all the hunters and see what happens. I know these issues seem very abstract and distant, but these are the same issues of certainty and fairness that goes through every judge's mind. And I hope this will leave you with kind of an insight into not only how to make arguments, but how judges decide cases themselves. Thank you very much. I'll see you guys on Wednesday.
Like that.